Okay, everybody, welcome to our first webinar of 2022. If you don't know me, my name is Mike Rafi, and I've been doing these webinars now literally for almost 3 years. Actually, it's the first one I think was in March or April of 2019. For some background, these used to be COVID webinars that I was doing once a week, mainly because we're all trapped inside, and I figured might as well put these out here and see how see if it helps people, see if I enjoy it. And since then, I have really liked doing these. And the feedback we've gotten is great. We have a pretty large group today. I guess everybody's, pretty large group. I'm looking at the list. I guess everybody's sitting inside today. Whatever you were going to do this morning has been canceled because of the rain, or at least you want to stay dry. So I appreciate you joining me. I don't want to let myself take for granted that y'all spend a half hour or an hour of your time with me once a month. I truly appreciate it. This is a ton of fun, and I'm excited about what we're going to talk about today. In the past, I have done webinars on one topic or two topics, but thinking back about the webinars I had the most fun doing and that we really shared as much as we could, they were a little quicker paced, and we did multiple topics for a shorter amount of time in a way that limits the topics I can talk about, because it means that I can't give you an hour on the new discovery, the new demand statute 91167.1 that applies to crashes past 2021, July of 2021. So I can't give you an extended breakdown of that in a 10-minute span and then go talk about something else. So we're still going to do those ones where we delve into some topics much more deeply than I will today. So on the contrary, on the opposite hand, this is what I want to do today. I want to talk about 5 things. Spoiler alert, there'll be a 6th. 5 things, though, that we are recommitting, refocusing, or trying for the first time in our cases this year to see how we can improve. I was talking to someone the other day about improvement and progress in general. And I'm going to give you these 5 things, but I want to temper that with the idea that if you try too many things at once, you will basically lose the idea or the ability to figure out, is it working or not? If you think back to 6th, 7th, 8th grade science class with the scientific method, you always had a control. And then you would change one thing. I am the proud winner of my 6th, 5th, 4th, some grade science fair. My mom still likes to talk about this for some odd reason, but I kid you not, I took eggs and I put different toothpaste on the eggs, and then the eggs were supposed to represent teeth, but the only thing that changed was the toothpaste. As we get older, we get all these ideas, at least I do, and my mind tells me to do 47 things at once, change 92 things, and then it works or it doesn't, and it's really tough to figure out, was it the change I made? Was it luck? Was it something else? So I'm going to tell you these 5 things, but I want to pull back and tell you, I don't think you should do all these 5 things at once if you're not doing them. Try 1, maybe try 2. Give it a significant amount of time. To me, that usually means either, if it's a daily basis, that means either 60 to 90 days, or if it's a change in a case, that to me means at least 1 cycle of cases. So if you turn over cases every year and a half, if you turn over cases every 9 months, whatever it is, you have to stick with it to find out if it's going to work or if it's not, and how it's going to affect your business in other ways. So with that preface, I'm going to start from the thing that we're going to change on the front end, which is how we're focusing on client sign up. I'm going to move to discovery, some things that we are doing, more importantly in this one, not doing in discovery with interrogatories and requests for admissions. We're going to talk about summary judgment, but probably not in the context that you think. Experts will be one of the last things I talk about, what we're doing, and again, what we're not doing with experts. And the last thing that I'll talk about as the 5 things we're focusing on this year is the idea of starting your case, starting your litigation case with causation as opposed to negligence. Causation instead of duty breach. Stick with causation in some cases to start, and I'll talk about that. Some of these, if you've joined me before, some of these I've talked about. And that's why these aren't necessarily 5 new things. It's 5 things that we're doing this year that we didn't focus on last year. One of the things one idea at least that I had for this webinar was to talk about demands. And if you've watched a handful of my webinars, you probably know that my thoughts on demands are to send more demands. No matter how many demands you're sending, send more. I thought about that being a topic here, but that's something we've always done. And sure, we're committing this year to send more demands, more offers of judgment, offers of settlement, unliquidated damages demands. We are always committed to that. So it's not something that we're changing in our practice. It's something we're continuously focused and committed to. So that didn't make the cut this time. So let me start with some things that we are focusing on that will hopefully affect and help how you sign clients up. If you haven't caught on over the last 2 years, the world has changed. I'm sitting here on a webinar, obviously, and that wasn't what I was doing in 2018 or 17 or any time before. I wanted to be in front of people personally, and I still do, but this is a really nice compromise. In that same vein, it's a really nice compromise to be able to sit in my office and have my folks who are that way sit in their offices and sign clients up. It also, though, takes a lot of the advantages you have meeting someone face to face. So one of the first things that we are really focusing this year on doing is converting clients or prospective clients from a phone call to a video. And if we can do that simultaneously, meaning they're on the phone, we say, "Hey, Miss Jones, so good to talk to you. Oh my Lord, you were in a crash. I hope you're doing okay. I'd really like to see and talk with you and have you see and talk with me. Do you mind if I video chat with you? Do you mind if we hop on Zoom, Skype, FaceTime?" You have to have all those options because if people don't, WhatsApp. So we are trying to commit to a face-to-face relationship with people, even in 2022, when things like DocuSign make life so much easier. The advantage of actually having someone see you is that they develop a personal relationship with you. They see that you care. I mean, hopefully you see I'm looking at my camera because I'm focused on y'all. I want you to see that I'm looking at you through the screen. And that's what I want to do with my clients. I also want them to see that I care about them. I'm focused on them. They're not, my phone's down here. They're not just on speakerphone and I'm doing 17 things at once. I want to be able to look at them for my benefit. I want to be able to look them in the eye and say, "Tell me about your injuries." And when they tell me the injuries, I want to show empathy visually. I want to say, "Oh my, wow, your car," maybe she pulls up a picture of the damage to her car. And I can say, "Wow, I am so glad that we're sitting here talking because that property damage, I mean, your car is smashed up. I'm so glad that you were able to walk away. I'm going to help you from here on out." And I think that goes a long, long way. We weren't having a problem, and I guess I'll mention this. We weren't having a problem and haven't been having an issue signing people up. Our conversion rate last year was the highest it's ever been. And I credit actually DocuSign for a large portion of that. But at this point, towards the end of last year and even earlier than that, there were so many clients that I literally had never seen. I mean, think about that. And maybe you have this in your practice. There are so many clients that we signed them up, ran their entire case, got the money, and then we're giving them the money. And maybe the first time I ever saw them was when they came to pick up their check because I begged them to come in because I wanted to see them. There were also a whole lot of clients that we mailed checks to, and COVID limits us in a lot of ways. Our clients, depending on what they do, their age, their health, their stance or cautiousness, they didn't want to come to the office. So it was really strange to not see my clients and not know what they look like, not be able to connect with them on a visual level. So we are going to make a concerted effort this year to see people. As basic as that sounds, my hope is that my clients get a better customer service experience by seeing me Also means I can call in, I can say, hey, and all of our folks have cameras, so they can do this in their own office. But if I've got another lawyer working on the case, or I've got a paralegal who's been working, I say, hey, Casey, come on, come inside. I got Mr. Smith on the phone. Well, she sits right there and says, hey, Mr. Smith, good to see you. So we do that with friends, we do that with family. And in fact, I remember in summer of 2019, saying to my friends, who some are in Atlanta, some are not, saying like, hey guys, why don't we all hop on a video call and talk? That right now seems so normal to me because we do it. But in whatever it was, June of 2019, saying to friends of mine who've been friends for 10 plus years, do you guys want a video chat? Felt strange to me. And we all kind of like, okay, I guess. Come to find out, or you fast forward months and we're doing that every week, kind of like the webinars I was doing back then. And the idea of being in person, face to face, it's a positive. I mean, I'm not going to run through that. You all know that already. So I'm hoping to improve the client experience during my clients' cases. I'm also trying to make sure that my clients see me for marketing purposes. I want them to see, you remember that guy? He was really nice. He was always engaged. I'm going to refer him to my friend, my sister, my cousin, my colleague, whoever. So I think it's going to help the client experience within the case. And I'm hoping that it generates more business on the back end, because it's hard to be memorable when you never meet your client. And it's hard for them to really care about you, because I want them to care about me. I want them to care about helping me as well. I want it to go be a two-way street. And I help them with this case, but when they leave the office and get the check, I want to say to them, here's how you can help me. Leave me a good review. Tell your friends and family about me. So I think that's going to improve it. One tip I'll mention that really improved our DocuSign sign up conversion rate, if that's what is concerning you, is we at first used to talk to somebody on the phone and then say, what's your email, what's your cell phone, whatever, and we will send you the DocuSign, and we'll call you in about an hour after you've had time to read through it, and we can talk about any questions, and we'll get out the form signed, and then we'll start working for you immediately. Our conversion rate was fine. It was average for us. We then said, instead of letting people get off the phone, send them the DocuSign while they're on the phone. And this may sound obvious to y'all, but it took us a little while to figure this out. But keep the person on the phone. Send them the DocuSign, even if it means, sir, hit your speakerphone and then look at your phone and let's walk through the contract together. But do it all right away. Don't make it another phone call. Don't make it an hour later. Don't make it 10 minutes later. Send them the DocuSign or whatever you use right away. That's helped our conversion rate. The last thing I'll say about the client kind of sign up process, and this goes through the entirety of the case, it's more of a communication tip, is there's a app or a program called ZipWhip, ZipWhip, ZipWhip. ZipWhip is a chatting feature. Now, if you have, I use 8x8 for my phone. Some people use Answer Connect, Ring Central, whatever all those ones are. Some of these have features similar to this. I've never seen one that has this feature. Correct me if I'm wrong. I'd love to know about it. But ZipWhip allows you to create groups, teams, basically, within a chat feature. So you have a phone number. Everybody in my office has a ZipWhip phone number. But what's nice is depending on what phone number we give out, if a client texts into that certain phone number, it can go just to me. It can go to me and Alex, who's next door to me. It can go to me, Alex, and Juliana, who's right there. We can decide what numbers go to what person or what group of people. Because what happens sometimes, at least in my office, is a client calls up. I say, hey, I'll hop on the phone. I say, hey, Mr. Jones, I'm running out of common names today. I've used a lot. But I say, hey, Mr. Jones, what's going on? And he said, you get my text? And I'm like, where'd you send it? And maybe he's texted only, I don't know, only Uni in my office, only her number. Or maybe he's texted somebody else. Maybe he's texted two people. I don't know. And I haven't seen the text and I haven't seen the response unless I go into my system, see if there's a note in the file. So what ZipWhip does, or similar products. I'm sure there's ones out there. I just don't know them. What they do is it lets you get a text and let it go to a group. So right now on my phone, I can look at different groups and different people, and I can see that Mr. Stanley has been texting me and Alex has been responding. So that way, if I talk to Mr. Stanley, I hop on my phone as I'm looking and I say, oh, okay, they texted 10 minutes ago and Alex said this, and I know what his answer was. I know where the conversation is going to pick up. That's helped a lot too, especially in the initial stages of client sign up, because we have clients who will send an email to so-and-so, here's some documents, text me and said, hey, here are the photos I took on my phone, send another email to somebody else. So we've tried to really narrow the limits, or at least narrow the group of people that are getting those messages, and speed up how quickly everyone in our office knows about them. Because what I don't want to have happen is Mr. Stanley call and say, hey, did you get the photos I sent? And Casey goes, no, I didn't. And that's true, she didn't. That's because I got them. So I want everyone to know what I have and what they have so we can talk with the clients. So hopefully that helps your client sign-up process. The crazy thing about client sign-ups and improving it is that very small changes done repeatedly will greatly improve your sign-up rate, your effective rate, and the relationship you have with clients. So these might, maybe they do to you, sound like small improvements or small things you can do. You may be thinking they're too small to even do. Why even do this? I'm telling you, do a little bit more, just a little bit. Hop on that one video call. Improve your intake system in one way, and the results are going to be instantaneous and they're going to be significant. That's why I like improving client signup so much, because I see the results right away, and you will too. All right, next thing, as I drink my 2022 resolution, by the way, was to drink more water. Hand in hand with that, it was also to drink more wine, if anyone's wondering. But you know, those two things go hand in hand. So those are my personal resolutions, among others. All right, discovery. Let's talk about discovery. The theme of 2022 in my office when it comes to discovery is this: cut the defense lawyer out of the case. As I say that, I am going to scroll. I'm smiling because there's some defense lawyers in here. Yeah. So for those of you that are defense lawyers, my goal is to cut you out of the case, is to get you uninvolved, or at least put you in a box where you are not necessarily the middleman between your client and me. I want to go around you as best I can. How do I do that? Can't talk to the defendant without their lawyer, right? As Lee Corso would say, not so fast. I can talk to represented clients during litigation. 30B6 depositions. 30B6 deposition is a deposition of a corporate representative. Corporation says, this is the person who's the most qualified to speak on these topics. And you have to tell them the topics. And therefore, go talk to them. So where we used to send, and here's the biggest change we're making, where we used to start a case and send interrogatories, requests for production, requests for admission, and send them right off the bat. Depending on the case type, we had a form. We would tailor it as best we could to the facts, but generally when you file a lawsuit, you may know a good bit, but you don't know everything about what documents the clients have or the defendant has, where they're kept, where they're stored, what their retention policy is for those documents, all that stuff. So instead of asking the defendant in written discovery, where their defense lawyer is just going to really respond, I mean, in massage answers to make sure that they are vague enough, to make sure that they don't really answer the question, object, maybe needlessly, to avoid all of that crap. What we are trying to do is skip the defense lawyer. So now, I'm going to come back to interrogatories in a minute, but now we send limited interrogatories. We send very, very limited requests for production. And then we immediately notice a 30B6 deposition, and the topics are about documents. The topics are about documents. I'll give you an example in a trucking case where we used to send, if we're in state court, used to send 35 interrogatories, I don't know, 70 requests for production, seeking everything from driver qualification file and everything in it, to maintenance records, repair records, photos, anything you can imagine. If you've done a trucking case, anything you can imagine, our list was listed in our RPDs. And I was very proud that our list was so comprehensive, because I knew I was asking for, in most cases, I was asking for almost everything that I would eventually need. And I was doing it right away. What would happen though, is I would get objections, I would get non-responses, I would get some documents, but not know, are these all the documents? Are they not? Did they find everything? So instead of having to go through the middleman, the defense lawyer, what I've decided to do is skip that. So now we send just a few RPDs for very basic things. If we want insurance information to confirm it, if we want, some ownership documents, let's say of a vehicle, very, very basic things that you should be able to open up a file and pull out and be done. But for the meat of the matter, what's in the driver qualification file? What screening process did you go through? What records do you have? All that stuff. We now notice that in the 30B6 deposition as a topic. And I'll switch this for a second to give you another example to make sure you know what I'm talking about. In the negligent security context, instead of asking for all reports, this was an old request we used to use, all reports showing crime or violent activity on the property for the last 5 years. I'd send that request, but I knew that the response was going to be, we object, it's vague. What do you mean by dangerous or crime? Which, if you don't know what crime means and you're a lawyer, I'm confused, but it's overburdensome for us to find this. It's not reasonably limited in time and scope, but here's some stuff. Here's 200 pages. And I wouldn't know, is that all of it? Where did this come from? Are you withholding documents? I had no idea. So instead we send an RPD, or excuse me, instead of sending an RPD, we send essentially that same request, but make it a topic in our 30B6 notice. So now instead of having the defense lawyer answer to me, filter the answer from his client or her client, and then give it to me, I skip over the defense lawyer, I get the records person or whoever is the most knowledgeable about the records from that company, and I say, hey, my name's Mike, I want to ask you about records. Do y'all keep a driver qualification file? Yes. Where is it? Well, we keep it online. How do you access it? Well, I log in. No, really. Tell me step by step how you access it. Well, I type my password in, I click here. I can download it by clicking this box. Okay, thanks. Does your driver qualification file online have everything? Oh, no, actually, we have the motor vehicle yearly reports. We keep hard copies of that. Oh, okay. Where are the hard copies located? Oh, in my office. Where? In a file drawer. Okay, do you have every employee's file? Yes. And everything that should be in the file, everything that all these reports should be in your file? Yep. If they're not in their file, would they be anywhere else? No, that's where they'd be. I now know for certain what they have, where they have it, and here's the kicker. I know how easy it is for them to get it. I know how easy it is for them to get it. So imagine I now send an RPD. I don't get the document right then. I'm learning what it is, where it is, and how easy it is to get. I now send an RPD and I say, hey, I'd like the driver qualification file that is on the blah, blah system. Next request. I would like the yearly motor vehicle reports that are contained in Steve's filing cabinet. Literally, Steve's filing cabinet. Imagine if I get a response back that says, your request to get the documents in Steve's filing cabinet is unduly burdensome. No, it's not. Imagine them going to a judge and saying, Judge, we had to object. It was too burdensome for Steve. That's my mini refrigerator. I'm gonna use that. Steve to walk over to his mini fridge, his filing cabinet, and pull out the drawer and pull out the file for, whoever the driver was. That's crazy. So it takes out the defense lawyer's ability to make your life difficult. That's what I'm trying to do. I'm trying to make my life easier, and I'm trying to keep the defense lawyer as uninvolved in the case. And when I say uninvolved in this context, I mean, I want to reduce his ability to affect the outcome. I want to reduce his ability to affect the outcome. I mentioned interrogatories, and I want to come back to that. Similar to RPDs, we used to send a whole bunch, everything that we think or thought we wanted to know in the case. I would then, and actually I realized this when other lawyers did this to me, and then I realized I was doing this as well. So I'm going to present it from this point of view. How many of y'all have responded to 50 interrogatories? They're stupid, they're annoying, they're obvious, whatever it is, and they're just formulaic. You respond to those interrogatories and you're like, all right, you feel accomplished. The depo for your client, let's say, is then a month later, and the first hour of the deposition is the defense lawyer asking you the same, or asking your client the same exact things that you already responded to in the interrogatories. I would sit there like this, going, why are you asking me this? Why are you asking my client the same stuff? We've already answered this to you in written form and verified it. Why are we doing this again? Are you going to send our RFAs then asking the same things to admit? Like, why? And my blood is starting, I'm getting all hot right now because it's just frustrating. But then I realized I was doing that to people and I didn't realize it. What not as bad, frankly, is and not as obvious, but I was certainly, sending interrogatories. Tell me every time that this vehicle was involved in a crash. Tell me every time that you've, been suspended at your job. I'm just making these up. Tell me every time that a tenant reported to management that there was a crime or that there was dangerous activity. And then in the deposition, I would ask those same things. And what I realized is it's because I didn't trust the words on the paper. Because they're filtered through a middleman, by the way. That's why, because they're filtered through a middleman. And I didn't know the process that the responding party went through to answer the question. So I didn't know if it was reliable. So I wanted to ask a human face-to-face in person. So we stopped asking so many interrogatories. It just didn't make sense. I would get my interrogatories back. I would get responses to them, and then I'd spend an hour, 2, 3, whatever it was, sorting through all the crap to try to figure out what I cared about, and what I didn't. And what I realized is there was a lot of interrogatories that I would read my interrogatory and I'd be like, don't care about that answer. And I just moved to the next one. And later I'd come back, but that wasn't an important one to me on the first pass. So why send them? Just stop. So that's what we did. We've stopped, and that's made my life easier. It's made our lawyers' lives easier. Maybe more importantly, and definitely more importantly, in fact, by asking it in a deposition, and in a deposition alone, we get better information because it's human to human, as opposed to human on paper to human on paper to client, and then reverse the cycle back with the middleman. It also has made us more confident in the responses we're getting. And it's made us really think about what matters in our cases, and what doesn't. Don't want to ask things that don't matter. It's a waste of time and it doesn't benefit anybody. I want to focus on what does matter. And that process of really narrowing down what we care about has helped us a ton. Last thing I'll mention is we are also committed to sending more requests for admission for things we know are true, but we want stipulated or admitted. And that has helped us, again, narrow the issues so that way we can focus on what matters. I'm going to give myself a plug here. If you haven't gotten the Verdict magazine, which is the GTLA produced magazine quarterly, I actually wrote an article about using requests for admissions in your case to narrow the issues and give you an advantage going into a trial, especially on causation, which I'll talk about later. Take a look at that article. You can find it through the GTLA website. If you have Instagram, my Instagram is Georgia_lawyer. It's in our bio. There's a link that you can click on to get to the article as well. So that's 2 places where you can find it. All right. Third thing I want to talk about is summary judgment. And I told you that I would be talking about summary judgment, not in the way that you probably thought. As a plaintiff's lawyer, when I think of summary judgment, I mainly think about how I'm going to have to respond to summary judgment. It's usually a defensive thing. I'm going to have to fight off a discovery judgment. I'm going to have to survive summary judgment. And I don't like that. I don't want to survive or fight off or, just barely muster enough to get to trial. I want to be on the attack. I want to be offensive because as the plaintiff, I have the burden, but I also have the ability to get facts quickly. As a smaller firm, as opposed to a defense firm where I'm working for an insurance company, where I have reporting requirements, I consider them the Titanic. They are slow moving ships. I want to be a cigarette boat that, is a speedboat that's, able to go wherever I want to go, into coves and back roads or, whatever, back swamps, whatever it is down there. I'm thinking of like, I don't know, the Keys or something. That's what I have in my mind. So we have started using summary judgment as a tool to put pressure on defense lawyers and also narrow the issues and figure out what really matters in the case. So how many cases do y'all have where the defense alleges that service was improper? I've got a couple right now. I always have a couple. And then I look at the affidavit of service that my process server filed, and it's person to person service. It's the right person, and I don't know why. I think and I guess I do know why. The reason that the defense made those defenses was that they didn't waive them, and the reality is they probably didn't speak to their client about how they were served before filing the answer, which I think is wrong, but that's what happens. So what we've started doing is we send an email that says, hey, you asserted these service defenses, you asserted a statute of limitation defense, you asserted a latches defense, all these things that just get thrown in there that are nonsense. Do you have any evidence to support them? If not, we're going to move for summary judgment. And we usually get well, we're still looking into it. Okay. Then we file a summary judgment on it. And then for the service context, for example, the defendant has 30 days to respond with evidence showing that there's a disputed issue of fact about service. And if there isn't, then that issue is gone. And we look at every single defense that is made in the answer, and we ask ourselves, can we eliminate this right away? Can we eliminate this right away? So if I get an answer that has 12 defenses, first one, service. Okay, I can handle that right away. Second one, the claim fails to state the claim fails to state appropriate form of relief. Okay, can I eliminate that one? The claim says that, here's a good one, claim says that my client was contributory negligent or comparatively negligent. My client was maybe rear-ended. Did my client do anything wrong? Let's eliminate that right away with summary judgment. Now, a judge may be apprehensive to grant that. A judge may be apprehensive to grant that because it's early in the case and the facts haven't been developed. But some of these are so obvious that you can kind of turn the screws and put some pressure on the defense lawyer right away. And it does two things other than just merely limiting the evidence. To me, it sets the tone for the case. It says, we're not going to play around with, these nonsense arguments. We're going to focus on the issues, and we are going to hold you accountable to the claims that you make, because you need, when you assert a defense, or really any claim for that matter, you need a reasonable basis to do that. Our client was sitting at the traffic light, stopped, foot on brake, is rear-ended by a truck. What exactly is your reasonable basis for saying that our client did anything wrong? And I want the defense lawyer to articulate that if they believe they have some evidence. And I want to know that right away before I really delve into discovery, so I can make sure that I answer those questions or develop information to answer those questions. The second thing it does is it makes the defense lawyer do something other than probably what they should be doing. If they're having to sit there and respond to my motion for summary judgment about service because they won't agree that service was proper for whatever reason, you know what they're not doing? They're probably, I shouldn't say I know, they're probably not developing the facts about other things that truly matter. They're not looking and reading medical records to understand causation. They're not going and interviewing witnesses because they're saying when they get to work, well, today I've got to work on this case. I've got this motion due or this response due in 10 days. I should probably go talk to this witness. Let me do the motion first or the response first, and then I'll talk to the witness. And maybe I get to the witness first. So it's almost like a distraction, but I wouldn't really call it that. It's it's holding the defense lawyer's feet to the fire. If they want to make arguments that are not supported by the facts, I want them to do that. And if they have to sacrifice other parts of the case from their side to do that, that's their fault. That's also a reason why we don't make claims that we don't think we can support. So that's what we're doing with summary judgment. We are also moving in the cases where there's admitted negligence and there's no, so you have an admitted negligence case, let's say it's a rear end crash. The defense has no experts about causation. They're mainly just cross-examining your doctors, your client's doctors. And what that says to me, bing, 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 is they're trying to steal closing. They're going to come to court and say, hey, we're the good guys. We want to give this person money. They've just been unreasonable what they're asking for. Here's what the fair value is. We've been moving for summary judgment on causation as well, And I think that helps because if they're at a discovery and don't have experts, and as you're approaching trial, and you're still, according to their answer, if the defense still, according to their answer, is saying that they don't agree that causation is present here, or that they dispute causation, or that the plaintiff hasn't proven causation, if you've got the right medical provider testimony and they have no experts to rebut that, there's no fact in dispute. So move for summary judgment on causation. I think that's something that we, speaking for plaintiffs' lawyers generally, something that we probably could do a lot more of. So we are looking for, moral of the story, we are looking for ways to move for summary judgment on issues, to eliminate them and to make the defense lawyer work on things that we don't believe are the most important things in the case, and will take them away from doing those important things. I mentioned causation, and I want to talk about that in another way too. I have mentioned this at least a handful of times in webinars over the last 2 years. And it's been, I keep saying 2 years, it's crazy, it's more than 2 years. But anyway, it has been something that I say, and then we do in my office, and then we kind of back off just because it hasn't been a focus for us. This is probably the thing I want to do the most over the course of the whole year. This is what I'm most interested in. How many cases do y'all have where you feel really confident about proving negligence, about proving duty and breach? You know, though, that your issue is causation. You know that proving causation is going to be the challenge because you know, let's say the defense lawyer has told you that he's going to hire a orthopedic surgeon to say, nah, these injuries weren't caused by the crash. He's going to hire a radiologist, probably the same one they hire in every case, to say, nope, no acute injury. They're going to hire a biomechanical engineer to say, force wasn't great enough. That to me is the majority of my cases, regardless of how obvious it is that the crash actually caused the injury. That's the playbook, right? I imagine y'all are experiencing that as well. So my RFAs, by the way, second plug, my RFAs my process for using RFAs to combat causation defenses, that's in the GTLA magazine verdict. It will go into more detail. So read that, give me a call, shoot me an email, whatever, if you want to talk about that. But what I'm going to suggest to you now, and what I've said before in some of these webinars, but I'm going to put a huge focus on right now, is start your case with causation. If your issue is causation, start your case with causation. One more time, because you got to say things 3 times so anyone understands them or retains it. If your case is about causation, start your case with causation. When you file the case, you being a plaintiff's lawyer have a distinct advantage over the defense, most likely. You have all of the medical records, at least you can ensure that you do before you file. So you can ensure that you have all the medical records, all the medical bills. You can go and already talk to your client's treating providers. You can interview them. You can get affidavits from them. You can hire experts before the defense even knows there's a claim. I mean, theoretically, right? If you get a claim a client directly in, you don't have to send a demand. You don't have to alert the defense lawyers. You can just sit there. If you know it's a big company, you probably don't even need to get the insurance. Maybe you want to send a preservation of evidence letter though. But from that point on, you are in complete control. You are, to use the Seinfeld term, master of your own domain and what you're going to do with the case. So when you file the case, you have the ability to have all of your ducks in a row, have everything planned. And I don't think that we, speaking as plaintiffs lawyers generally again, do that enough. I think we file and then say, well, I'm going to get on this now that I filed. What I'm suggesting and what I'm telling you to do is, especially when causation is your issue, do as much as you can before filing to get your causation arguments, evidence, whatever you got, sorted out. Then file. When you get the answer, or even you can do it before, I would suggest get the answer first. Say to the defense lawyer, I want to take depositions of the treating doctors. I want to do that right now. They'll say, they can't stop you from taking a deposition. Go and take that doctor's deposition, your causation expert, and get the depo done. You are now 2 months, 3 months into the case at most, and you have the one issue in your case that you know is a problem. When I say problem, I mean that's going to be a contested issue. It may not be a problem. The defense might just try to make it a problem. But you have sorted that issue out before filing the lawsuit, and then you are able to get the evidence you need to meet your burden and persuasively show the jury that your client is actually injured in the way they say. You can do that right up front. And then, following that last piece of advice, at that point, there's no disputed evidence about causation. Move for summary judgment. So, file, depose the doctor, your treating doctor, move for summary judgment. What does that force the defense lawyers to do? It forces them to go and hire an expert if they need to and do it really quickly if they haven't done it already. It forces them to say what their arguments are about causation at the start of the case. You still have time in discovery if they say something that you're not expecting or that you think is wrong and you can correct. You still have time to go develop information contrary to their statements. The habit that we as plaintiffs lawyers and all lawyers that do personal injury work on the plaintiff side or the defense side, the habit that we fall into is that it has to go complaint, answer, written discovery, responses, 6.4 letter, maybe a motion to compel, fight about some stuff that probably doesn't matter in written discovery, depositions of your clients, depositions of fact witnesses, let discovery close before you go and spend the money with experts, whether they're hired experts or treating providers. See if you can negotiate the case and resolve it. That may work for maybe even the majority of cases. I don't know. But I think that you are going to get better results, meaning on one hand, quicker, and on the other hand, more money. You are going to get better results if you deal with your issue in your case, which in this context, I'm saying it's causation. To deal with causation off at the front of things, do it right off the bat. So instead of going down the traditional road, if liability is obvious, if it's a rear end crash, why do you need to go and depose people right away that are going to talk about the crash? You know what happened. Maybe you have photos, maybe you have dash cam video. You know what happened. There's no real dispute about that. The issue in the case is going to be whether the crash caused the injuries. So deal with that right at the beginning. All right, I can't emphasize that enough, that if you do it at the front end, it gives you, it puts you in a position of power because you have more information than the other side earlier on in the case. You've been able to develop your information and get it set up to attack. You're able to fend off the responses because you still have time in discovery, and you're forcing the defense lawyers to disclose their strategies and disclose their facts right away. How many cases have you been in? I've been in a lot, where you're really close to trial and suddenly the defense lawyer pops up and says, here's a causation expert that we're now disclosing. And you say, what the heck? This case has been going on for a year, 2 years, whatever it is. Where's this expert been? And if it's in state court, it's generally totally fine. The reason they were able to do that is because they didn't have to fight off a summary judgment on causation. If you file that summary judgment on causation, they have to, it's red alarm, woo, woo, woo. They have to make sure that they present all of their arguments and And they're not going to hold anything back, because if they're wrong, they lose the case. And that's because you've identified and then attacked the issue that is the case. You're putting all the other crap aside. All right, very last topic, experts, specifically defense experts. For the last 2 or 3 years, we have our focus on experts, defense hired experts, has been to discover every single piece of information that I possibly can about the expert, and make sure I have every shred of evidence, every shred of discoverable material before I take the deposition. It's been a whole lot of work, and we've developed a whole lot of information about who knows how many experts. In fact, I have a case right now that, pursuant to the strategy, the judge is on the eve of appointing a special master, because there's issues going on with the defense expert not providing us the information that we've requested, making it very difficult for us. And it's gotten to the point where even the judge is saying, I need a special master, because this is an issue that's taken a life of its own. So our new consideration, is what I'll call it, is the time, effort, and delay in the case of going that route. There are certainly many cases that we are going to continue to push down I want everything that I can possibly get about this expert. I want to send them a subpoena for documents. I want the defense firm, what we typically do, at least what we've been doing, is we send a request for information to the defense expert, to the defense insurance company, and to the defense firm, because I'm looking for the connection between all of them. I want to know how many cases they've all been involved in, how much money they've all paid each other. I want to know all of that. 90% of the time, though, I don't use that information, because it isn't the most important, most persuasive evidence that I can use to try to get the best result for my client. So we are going to, this year, our firm is going to do a better job of considering whether we should go that route, or whether we should go a more efficient and likely effective route for the case. This issue that's going on with the special master in a case I have in Fulton County, like I said, it's taken a life of its own, and it's been an issue for 6 months. And we're still not done with it. So that has taken a detour. In a lot of ways, you at least could think that is not the most effective way to resolve the case. I care about effectiveness more than efficiency, but efficiency is a part of effectiveness. If you think about it, effectiveness is how successful you were in the grand scheme of things. I don't necessarily want to do things the quickest route just because they're the quickest, but if it makes a considerable difference to my client to get a faster resolution, that's certainly a consideration that we should have. So with experts, we've made a pretty sophisticated, I think, filing system for experts. And we have saved as much information as we can about the experts that we've seen, as well as ones we expect to see and haven't deposed or haven't had in cases yet. The ones that whatever listservs you're on or email chains you're on, the ones that everybody talks about, your frequent flyers. We've got essentially a database about those people. And instead of going and deposing them about every single topic in the world, we are trying to narrow our focus to things that we don't know, which are usually very case-specific things. But in terms of background, I'll give you the Barry Jeffries example. Instead of me spending even 10 minutes in a deposition asking Barry Jeffries how much he has made in whatever years, I already have that information in 97 depositions. I don't need to go ask that. So we're trying to really limit down what we spend time on, because we are, our whole theme, big picture, and this is kind of what I want to end with. Our big picture theme in 2022 is do what matters. Do what matters. Especially on the plaintiff side, as plaintiffs' lawyers, our clients are generally not legal experts. When I did defense work, I worked at a big law firm. I had a partner, but even that partner had somebody in let's say Georgia Power had a claims person who was a lawyer in Georgia Power. That person had to answer to the general counsel. If you had an insurance company involved, then you had to answer to a lawyer in the insurance company, and so on and so on. I don't experience that. My clients, I was in mediation yesterday. I resolved a really good case. And the client said to the mediator, I trust Mike. Mike's led me through this whole case. Whatever Mike says. Now, I don't necessarily want that burden or that responsibility. I want to educate my clients so that way they can make good decisions with me, with my help. But it's true. I mean, I am their Sherpa, getting them up to Mount Everest, because, when you're suing companies like Walmart and Kroger and Google and whoever else, that is like climbing legal Mount Everest to win. So I'm their Sherpa. I am their trusted advisor. And I have the ability to not worry about things and not do things that don't matter. So our firm's focus in 2022 is to do what matters. And to figure that out, we need to think. That's the hardest part of this job. We need to really think. We need to critically analyze what is important. And as basic as that sounds, if you really think about it, and if you're really honest with yourselves, and I'll be honest out loud to all of you, I've gone through entire cases and not realized what was important until the last minute. Sometimes it was my fault that I just couldn't see the forest through the trees. Other times it was that the defense kind of yo-yoed me around and did a good job of making me, realize, or preventing me from realizing what matters. Other times something small that didn't matter later became huge in the case. But I know if I would have sat down and really, really thought about it, reviewed the file with a clear head and a clear mind and a clear conscience, and said, what does matter? Forget everything I've thought about the case, put all my preconceived notions aside, put all my assumptions, all my reasonable theories and hypotheses, put all of them aside. What matters today in this case, and what's going to matter in 6 months, 12 months, and 2 years, whatever it is? That is going to make you a better lawyer. It's going to make your practice more efficient, and it's going to benefit your clients because they're going to get more effective results. They're going to get the money. We're going to get more money because that's all we can get our clients is money. We're going to get them more money, and we're going to get them that money quicker. And that's what our civil justice system allows us, and the only thing it provides for people who are injured. So don't run away. Don't be shy of asking for more money and quicker money. That's why we're here. That's what our job is, and that's the only thing the law allows. You're not a bad person, an evil person. There's nothing wrong with asking for money in this situation. So I told you there was a sixth thing that I would talk to you about, and if you've caught on to how I present these webinars, usually the last thing that I tell y'all is a thought that's in my mind that hopefully, big picture, maybe you can relate it to the law, maybe you can relate it to your life, maybe it's just something I want to share with you for my own benefit. But today what I want to share with you is importance. I told you I'm going to say it again, more times I say it, more times you'll remember it. I told you our 2022 theme at our firm is to do what matters, do what's important. I would respectfully suggest to you, even though I have zero qualifications to say this, but as a human to another human, I would tell you that mantra, that theme is a really good theme for your life. Do what matters. For me, I'll give you a dumb example. For me, I guess it's been 4 or 5 years ago. If you are friends with me on Facebook, if you're not, go ahead and add me. But if you're friends with me on Facebook, you used to see me being a lot more active, especially what was going on in the political world at that time. I felt the undying need to say things that was like talking into a hurricane or a tornado and not getting a response, or getting a really bad one. So I don't know the last time I posted on Facebook. In fact, I just don't want to. I have Facebook for business purposes. That's a stupid example, but it's a stupid example of me trying to focus on what matters in my life and not doing all the other stuff. And Facebook, dumb as an example of this as this is, does not matter in my life. I've read more over the last year than I ever have. I'm working on a book right now that I've really enjoyed, and I don't want to go to sleep at night. I want to finish the book, or I don't want to pick up my phone. I want to finish the book. So what's mattered to me in 2021 going into 2022, And what I want to focus on in this year is, in my life, is focusing on what is important and getting rid of all the other nonsense. That could be going to the mall and walking around and considering what crappy t-shirt you're going to buy. That probably doesn't matter. Maybe having the nicest shoes, maybe it does matter to you, and that's fine, but maybe it doesn't. Maybe, watching the newest season of whatever on Netflix does matter to you, then go do that if that makes you happy. But if it doesn't, if it just, you're just sitting there making your brain mush and not doing anything that really truly makes you happy, then don't do it. And the last thing I'll say is, I'm not a believer that you have to be productive at all times. I don't think you have to be working. I used to think that. I don't think that anymore, but I don't think you have to be productive at all times. I think your body and your mind need downtime. So when I say focus on what matters, make sure you factor in that your health, your mental acuity, all that matters. So do your best to focus on what matters in your life. Do your best to focus on what matters in your cases and your law firm, because that'll benefit you and your clients and your employees. Don't forget about those folks. And if you can do something to help someone else's life, I bet you'll find that that will matter a whole lot to you. If you can improve someone's life, even in a small way, that is the stuff that really matters to us. And I hope that's the things that matter to you. It's part of the reason that I do these webinars, because I want to improve your practices. I want to improve your life. And I want you to have a better outlook on what we're doing, because a lot of the stuff that we do and have to deal with as lawyers generally is very difficult. It's taxing on our minds and it's frustrating. So if you can find what's important to you, and you know that when your workday is over, you have something to look forward to. Hopefully you can find things at work to look forward to as well. But if you can find that thing that you love, go and do that. Make it a priority in your life and focus on what's important. And I think that that will improve every aspect of your life. So with that and the unsolicited life advice that I enjoy giving at the end of these things, I appreciate you joining me. And that ends our first webinar of 2022. Our next one will be the first Tuesday of March, barring me having a trial. But even if I do have a trial, I actually will likely turn the webinar over to one of the other folks in my office. But the way COVID's going, unfortunately, right now, and the way courts are, I suspect that I will see you all the first Tuesday of March, or excuse me, first Thursday of March, which is March 3rd.